My name is Matilda Harper. I'm 38 years old, and for most of my adult life, I was known as the steady one. I live in Portland, Oregon. I'm a financial compliance analyst by profession, which is a polite way of saying I read contracts people don't want to read and notice patterns other people miss. At home, though, that's not how anyone saw me. To my husband, Daniel, and to most of our friends, I was the calm one, the agreeable one, the one who didn't make scenes, the one who trusted easily. I've always had a soft voice. I listen more than I speak. At dinner parties, I ask questions and refill glasses. At family gatherings, I remember birthdays and keep track of everyone's dietary restrictions. People mistake that for simplicity. They assume that because I'm not loud, I'm not calculating. Because I'm patient, I'm passive. I never corrected them. This story isn't about revenge. It isn't about dramatic courtroom speeches or explosive confrontations. It's about something quieter than that. It's about what happens when the person everyone assumes is the least powerful turns out to be the one who has been paying attention the longest. 3 years ago, my husband filed for bankruptcy behind my back. I didn't find out because he told me. I found out because a routine piece of mail, something that looked like junk at first glance, didn't sit right with me. And when I followed that thread slowly and methodically, I uncovered something he never thought I would see. The asset he concealed turned the entire case upside down. But the real story isn't the legal twist. It's the emotional shift that came long before the paperwork. It's about the months, maybe years, when small cuts were disguised as misunderstandings, when decisions were made for my own good, when financial conversations happened around me, not with me. It's about how silence can be mistaken for ignorance, and how sometimes silence is simply observation. I won't dramatize what happened. There were no screaming matches, no plates thrown, no cinematic storms. There was only a growing awareness that the life I thought I was building with someone was being quietly rearranged without my consent. If you've ever been underestimated, if you've ever felt that something wasn't adding up but couldn't prove it yet, if you've ever been told you were overthinking when your instincts were simply ahead of the evidence, then you may understand this story more than you expect. I'm going to tell you exactly what happened, step by step, not to expose him, but to show what it means to reclaim your footing without raising your voice. Have you ever realized you were the only one in the room who didn't know the full truth about your own life? To Daniel, I was solid. That was the word he liked to use when he introduced me to people. This is my wife, Matilda. She's solid. Not brilliant, not sharp, not strategic. Solid. At first, I took it as a compliment. Solid sounded dependable. It sounded like something you could build on. But over time, I began to notice the tone he used when he said it. A quiet pride, but not in me, in what I represented. Stability, predictability, non-resistance. Daniel worked in commercial real estate development. Big personalities, big risks, big dinners where men spoke loudly about leverage and timing and playing the long game. I attended those dinners in understated dresses, hair pulled back, listening carefully while they spoke over dessert about acquisitions and debt structures. Occasionally, someone would ask what I did. Compliance, I would say. Their eyes would glaze slightly. The conversation would pivot back to Daniel. At home, our dynamic wasn't hostile. It was arranged. He handled big vision finances, investments, deals, expansion ideas. I handled household finances, mortgage payments, utilities, insurance renewals, tax documentation. It seemed efficient. He would say things like, "You're better with the small details." And I would smile, because technically that was true. But what no one realized was that I wasn't just tracking grocery receipts, I was tracking patterns. I knew exactly when our joint savings fluctuated. I knew when wire transfers occurred that weren't aligned with quarterly projections. I knew when Daniel's tone changed around certain phone calls, not because I was suspicious, because I was trained. When you grow up watching creditors call your childhood home, you develop a relationship with numbers that's almost emotional. I learned early that financial silence can be louder than arguments. Those missing statements mean more than raised voices. Still, in our marriage, I allowed a version of myself to be convenient. Daniel liked to believe he was the strategist, the risk taker, the one carrying the future on his shoulders. And I let him believe that. Not because I agreed, but because correcting him felt unnecessary at the time. Our friends saw me as calm, supportive, a good listener. His colleagues saw me as background. Even his parents treated me like a pleasant accessory. His mother once said at Thanksgiving, Daniel's always been the ambitious one. You must feel lucky to have someone so driven. I smiled and passed the cranberry sauce. It wasn't that I lacked ambition, it's that my ambition was quiet, structured, rooted in stability rather than spectacle. There's a particular kind of invisibility that doesn't hurt at first. It feels peaceful. No competition, no spotlight, no expectation to perform. But invisibility, over time, becomes an assumption. An assumption becomes permission. Daniel began making decisions without consulting me. Not about dinner plans or weekend trips, but about refinancing structures, about shifting liquidity between accounts. He would summarize things after they were already done. I moved some money around. It's better tax positioning. I leveraged the equity. It's smart timing. I would ask questions, calm ones, specific ones, and he would respond with gentle dismissal. You don't need to worry about that. It wasn't said harshly. That's what made it so easy to ignore. To them, I was low maintenance, undemanding, secure in my role. They mistook composure for complacency. They didn't realize that every time someone underestimates you, they reveal more than they conceal. And at the time, I was still deciding whether that knowledge would matter. The first time something truly unsettled me, it didn't look dramatic. There was no secret envelope stamped in red, no mysterious phone call taken in another room. It was a dinner. We were at a rooftop restaurant downtown with two of Daniel's business partners and their wives. The air was cool, city lights reflecting off the glass railing. Everyone was relaxed in that way people are when they believe they're among equals. The conversation shifted to market instability, interest rates, liquidity concerns. One of the partners joked, "At least none of us are dumb enough to over-leverage right now." Daniel laughed, not politely, not casually, knowingly. I noticed it because it didn't match the tone of his recent stress. For weeks, he'd been quieter at home, restless, checking his phone late at night. The partner asked, "You still holding that property in Arizona?" Daniel took a sip of his drink. Not exactly. There was a brief pause, a flicker between them. "Smart," the other man said. "You got out?" Daniel shrugged. "Let's just say I repositioned." The table moved on. Someone ordered another bottle of wine. But I felt something shift. Because Arizona wasn't something we had discussed repositioning. In fact, the Arizona property, an investment duplex outside Phoenix, was something I'd specifically asked about 2 months earlier. He'd told me we were holding it long-term, that it was a stable rental income, that there was no reason to adjust. I didn't interrupt dinner. I didn't press him in front of anyone. But on the drive home, I asked gently, "What did you mean about Arizona?" He kept his eyes on the road. "It's nothing." It didn't sound like anything. He sighed, like I was asking about a minor inconvenience. I shifted it into a different structure. "It's just smarter asset protection." "Why didn't you mention it?" "I didn't think it was necessary to run every tactical decision by you." There it was. Not cruel, not loud, just dismissive. I let the silence stretch. It would have been easy to tell myself he was right. He operated in faster financial environments than I did. Real estate moves quickly. Structures change. But that wasn't what bothered me. What bothered me was the phrase, "run every tactical decision by you." Not us, you, as though I were an outside consultant who required briefings. When we got home, he went upstairs to shower. I stayed in the kitchen, staring at the dark reflection in the window. I didn't feel angry. I felt excluded. And exclusion is a subtler wound than betrayal. It's harder to point to, harder to accuse. The next morning, I logged into our shared financial dashboard. The Arizona property was no longer listed under jointly held real estate assets. It had been transferred 3 weeks earlier. Not sold. Transferred. To an LLC I didn't recognize. The registration address wasn't our home. It was a commercial mailbox downtown. My chest tightened, but not from panic, from recognition. He hadn't told me because he didn't think I would look. And maybe until that moment he was right. That was the first small cut. Not the bankruptcy, not the hidden filings, just the quiet realization that financial decisions were being moved out of shared space. I closed the dashboard and went to work as if nothing had happened. I didn't confront him again, not because I was afraid, but because I needed to understand whether this was an isolated decision or the beginning of a pattern. And patterns once seen cannot be unseen. If you don't challenge the first shift, the second one arrives more easily. After Arizona, I told myself a version of the story that made everything comfortable again. Daniel works in risk. Risk requires flexibility. Flexibility sometimes requires speed. And speed, I reasoned, sometimes excludes consultation. I wasn't naive. I was rationalizing. The next few months unfolded without a visible crisis. We hosted friends. We attended fundraisers. We went hiking on Sundays like we always had. From the outside, nothing had changed. But inside the structure of our marriage, something subtle had been rearranged. He began using language that felt less collaborative. I've decided to, I moved some capital into, I'm restructuring. When I asked clarifying questions, he'd respond with a softened smile. Not irritated, just indulgent. It's complex, Matilda. You don't need to get into the weeds. I work in the weeds. That's my profession. But I let it go. There's a particular psychological trap that happens when disrespect is gradual. You don't label it disrespect. You label it a personality difference, stress, timing. I started noticing smaller things. Statements from banks addressed only to him, even when the underlying debt had once been joint. Notifications from credit monitoring services that never showed up in our shared inbox anymore. A shift in how often he referenced my portfolio instead of our assets. Each instance alone was explainable. Together they felt curated. Still, I didn't confront him. Not yet. Instead, I adjusted myself. I stopped asking questions in real time. I observed. I listened more carefully during his calls in the other room, not for content, but for tone. I noted when his cadence tightened, when he used phrases like temporary exposure or bridge positioning. I began keeping more detailed notes in my black leather notebook. Dates, account changes, offhand remarks. It didn't feel dramatic, it felt responsible. There's something dangerous about being the reasonable one in a relationship. You begin to absorb discomfort quietly because you're capable of holding it. You convince yourself that emotional restraint is maturity. And in many cases it is. But restraint without reciprocity becomes erosion. One evening, his mother called. I answered because he was in the shower. She asked casually, "So, how are you feeling about Daniel's expansion plans?" I paused. "What expansion plans?" "Oh," she said lightly, "maybe he hasn't shared yet. He mentioned leveraging some of the residential holdings for something bigger." I kept my voice even. "We've talked about some general ideas." "Good," she replied. "You know how he is. Vision first. Vision first." That phrase stayed with me. Vision first. Where did I fit into that order? I didn't confront him about that call either. Instead, I watched how often he updated others before me. It became a quiet tally. Colleague informed before wife. Mother informed before the wife. Attorney consulted before wife. The normalization happened gradually. No raised voices, no ultimatums. Just the steady repositioning of me from partner to peripheral. And here's the uncomfortable truth. Part of me participated in that demotion because correcting it would have required conflict, and conflict would have forced clarity, and clarity might have revealed something I wasn't ready to see. So I told myself I was choosing peace. But peace built on incomplete information isn't peace. It's suspension. And suspension can only last so long before gravity returns. It didn't happen with the conversation. No one formally reassigned me. But one day, I realized I had been given a role. Reliable, supportive, unquestioning. The woman who keeps the house steady while the visionary takes risks. The woman who doesn't stress her husband with details. The woman who trusts. Trust is a beautiful word. It's also a convenient one. The moment I truly saw the role I'd been placed in was at a charity gala Daniel insisted we attend. Black tie, soft jazz, a ballroom filled with people who referred to each other by last names. Daniel was in his element, shaking hands, laughing loudly, speaking in confident summaries about projects I had only heard fragments of. At one point, a woman I barely knew turned to me and said, "You must be so proud. It takes a special kind of wife to let a man operate at that level without interference." "Without interference," I smiled politely. "I prefer informed partnership," I replied. She blinked slightly, then laughed as if I'd made a small joke. But I wasn't joking. Later that evening, I stood near the bar while Daniel spoke to a lender I recognized from past refinancing paperwork. The lender clapped Daniel on the shoulder and said, "Bold move consolidating like that. High risk, high reward." Consolidating? That wasn't language used in passing. That implied structural change. Daniel glanced at me briefly, just long enough to register that I'd heard. Then he looked away. That was the moment. Not anger, not shock. Recognition. I had been categorized. In his professional world, wives were either volatile liabilities or silent stabilizers, and I had proven myself to be the latter. Predictable, safe, contained. It wasn't cruelty, it was an assumption. He assumed I valued emotional calm over financial transparency. He assumed I preferred comfort over confrontation. And maybe until recently I had. But something about standing in that ballroom, listening to men discuss leverage strategies that directly affected my legal and financial position, shifted something fundamental. I began to see how carefully curated my access had become. I handled taxes, but not the upstream structuring. I managed expenses, but not asset migration. I signed documents, but only after summaries were provided. It was an elegant partition, one that left me appearing involved while strategically uninformed. That night, when we got home, he loosened his tie and asked casually, "You okay? You were quiet." "I was listening," I said. "To what?" "To the things you assume I don't understand." He gave a small, amused smile. "Matilda, don't start inventing problems. Everything is under control." "Under control." I nodded, because here's what I understood in that moment. Control isn't about who speaks louder. It's about who has full information. And for the first time, I was certain I didn't. The role I'd been assigned was not a partner. It was a stabilizer. Background, reassurance, and roles once identified can be stepped out of. But not impulsively, quietly, strategically. The shift didn't happen at a gala. It didn't happen during an argument. It happened on a Tuesday morning in my own kitchen. The house was quiet. Daniel had left early for a meeting. Rain tapped lightly against the windows. I was standing at the counter, reviewing our quarterly expense sheet before logging into work. I noticed a line item that didn't belong, a legal retainer. Not unusual in his industry, but this one was tied to a firm we had never used before. The amount wasn't catastrophic. It wasn't even dramatic. It was deliberate. I stared at the name of the firm longer than necessary. Something about it felt clinical, specialized. I opened my laptop and searched the firm. Corporate restructuring, insolvency advisory, bankruptcy protection. I didn't feel panic. I felt stillness, because this was no longer about communication style. This wasn't about ego or vision first. This was structural, and he hadn't said a word. I didn't call him. I didn't text him. I didn't accuse. Instead, I did what I've always done when something feels unstable. I gathered information. I pulled archived bank statements from the last 18 months. I compared outgoing transfers against known project timelines. I noted when liquidity tightened, when credit lines expanded, when balances moved between entities. I noticed something I hadn't fully allowed myself to articulate before. The Arizona transfer wasn't isolated. It was the first visible piece of a larger repositioning, and I had been excluded from every meaningful stage of it. The realization wasn't explosive, it was clarifying. There's a difference. Explosions are emotional. Clarity is structural. Clarity doesn't shout, it reorganizes. I closed my laptop and sat back in the kitchen chair. The rain had slowed. The house felt unfamiliar, not because it had changed, but because my understanding of it had. For the first time, I stopped asking, "Why didn't he tell me?" and started asking, "What is he protecting?" People hide two things, shame or leverage. Shame collapses inward. Leverage moves strategically. Which one was this? I thought about every dismissal. Every "you don't need to worry." Every summary instead of consultation. If this were simple embarrassment over a failed deal, there would have been frustration, visible stress, confession dressed in pride. Instead, there had been compartmentalization. Intentional. The shift inside me wasn't anger. It wasn't heartbreak. It was the decision to stop being emotionally reactive and start being structurally aware. That morning, I took my black leather notebook from my bag and wrote a single sentence. If there is restructuring happening without my knowledge, I need full visibility. Not confrontation, visibility, because visibility precedes power. And power doesn't require volume, it requires access. When Daniel came home that evening, he kissed my cheek like always, asked about my day, complained lightly about traffic. I watched him, not suspiciously but attentively. He looked composed, controlled, which meant whatever he was doing, he believed it was contained. That was the day something shifted. Not in him, in me. I stopped hoping for transparency and started preparing for discovery. There's a version of silence that feels like fear, and there's a version of silence that feels like alignment. Mine changed that week. I stopped asking Daniel questions about finances entirely, not because I didn't care, because I needed him to believe I didn't notice. At dinner, when he casually mentioned tightening exposure, I nodded and asked if he wanted more rice. When he stepped outside to take calls, I didn't glance toward the door. When envelopes arrived addressed only to him, I placed them neatly on his desk without comment. If he were monitoring my reactions before, he would have found nothing. And that was intentional. People relax around what they believe is stable. The less reactive I appeared, the less guarded he became. It was subtle at first. He stopped minimizing browser windows when I walked past his office. He began leaving documents in his briefcase overnight instead of locking them away immediately. He assumed the absence of questions meant the absence of scrutiny. But silence when chosen becomes strategic. At work, I requested continuing education credits in corporate insolvency frameworks. It wasn't unusual for my profession. Compliance analysts often expand into restructuring literacy. No one questioned it. I reviewed federal bankruptcy filings, not specific to him, just procedural patterns. I learned how individuals sometimes shield assets before filing, the legal boundaries, the gray areas, the timelines. I didn't assume he had filed anything. I assumed I needed to understand the landscape before deciding what I was standing on. There's something calming about studying structure. It removes emotion from speculation, and speculation, without evidence, can turn a reasonable person paranoid. I refused to be paranoid. I would be precise. At home, I adjusted in ways he didn't register. I began routing more of my personal income into a separate account in my name only, not hidden, just unshared. I updated my access to our joint tax portal, ensuring I had independent authentication rather than relying on his credentials. I ordered certified copies of property deeds, not because I suspected forgery, but because I wanted timestamps. Each action was legal, transparent, quiet. If he ever noticed, I would simply say I preferred redundancy. Redundancy sounds responsible. Meanwhile, Daniel seemed lighter. That was the strange part. Instead of appearing burdened by financial strain, he looked almost relieved, as though something had already been decided. One evening, while we were watching television, he said casually, sometimes protecting your family means making hard calls they don't fully understand. I turned my head slightly. Protecting them from what? From unnecessary stress. I held his gaze a second longer than usual. Stress comes from uncertainty, not information. He smiled, but it didn't reach his eyes. Trust me. Trust me. That phrase no longer comforted me. But I didn't argue, because by then, I understood something clearly. If he were restructuring in ways that involved legal risk, there would be paperwork, timelines, public records. And public records don't respond to trust. They respond to fact. Silence wasn't weakness. Silence was patience. And patience, when paired with preparation, becomes leverage. Preparation rarely looks dramatic from the outside. It looks like routine. That was my advantage. Daniel believed he understood my rhythms. Work, gym twice a week, grocery shopping on Thursdays. Quiet evenings with spreadsheets open on the dining table. He did not realize the spreadsheets had changed. I began building a parallel financial map, not what he told me existed, of what could be verified independently. County property records are public. Corporate registrations are searchable. UCC filings leave trails. It's not glamorous work, but it's thorough. I started with the Arizona LLC. The registration listed a manager, not Daniel directly, but a holding entity I didn't recognize. That holding entity, in turn, traced back to a registered agent I had seen once before in our closing documents years ago. I followed the chain carefully. What I discovered wasn't illegal. It was intentional. The Arizona duplex had been moved into an LLC solely managed by an entity not listed under our marital assets in recent tax summaries. That entity had opened a line of credit using the property as collateral. The credit line had been drawn down, substantially, and none of that had appeared in our joint liability overview. I didn't react emotionally. I documented dates, filing numbers, registered addresses. Then I brought in the search. There were 2 additional corporate registrations within the last year, both tied to mailing addresses different from our home. One was formed 6 months after the Arizona transfer. The timing mattered, because in insolvency planning, timing is everything. I cross-referenced that with the legal retainer I'd found. The law firm specialized not just in bankruptcy, but in asset shielding prior to bankruptcy filings. That phrase stopped me. Asset shielding. Not debt resolution, not restructuring for growth. Shielding. I leaned back in my office chair at work and let that settle. If someone anticipates insolvency, they have 2 options: transparency or protection. Protection requires repositioning assets before creditors can access them, and repositioning without informing your spouse is an oversight. It's a strategy. Still, I did not accuse him in my mind. I tested alternate explanations. Could he be insulating me from risk? Could he be isolating volatile assets from stable ones? Could this be temporary containment? Possibly. But then I did something simple. I ran a personal credit check on myself. There it was. A joint line of credit I had not authorized in the past 8 months. It was technically legal, opened under our shared marital profile, but it was extended primarily under his operating entities. The exposure, however, had my name attached. That was the first moment my breath changed. Not from betrayal, from understanding. If bankruptcy were filed under his personal name while certain assets had been preemptively shielded, creditors would examine marital assets. unless those assets had already been repositioned beyond reach, and unless the liabilities were structured to fall in shared territory. That afternoon, I scheduled a consultation, not with a divorce attorney, with a financial forensic specialist. I didn't tell anyone, I simply asked neutral questions. What are common patterns in pre-bankruptcy asset transfers? How are concealed properties typically traced? What legal obligations exist between spouses regarding disclosure? The specialist didn't know my situation. I framed everything hypothetically. But as he answered calmly and clinically, one thing became clear. If someone filed for bankruptcy while having concealed assets under separate entities, and that concealment was proven, the court would not look kindly upon it. The asset he concealed, if discovered, would not just complicate the case. It would turn it upside down. I closed my notebook that evening with steady hands. Daniel came home cheerful. He kissed my forehead and said, "Everything's going to work out." I smiled, because now I understood something he didn't. Preparation is invisible until it isn't, and I was no longer guessing. I was positioning. The official notice arrived on a Thursday afternoon. It wasn't dramatic, no courier, no raised voices at the door. Just a standard envelope forwarded from a secondary mailing address we rarely used. I recognized the formatting immediately. United States Bankruptcy Court. Chapter 7, Filing. Filed by Daniel Harper. I sat at the dining table and read every page twice. Date filed 3 weeks earlier. Assets declared: limited personal property, minimal liquid funds, distressed real estate holdings. The Arizona property was not listed. Neither were the two recently formed entities I had traced. He had filed, and he had not told me. The strangest part wasn't shock. It was confirmation. All the preparation I had done, every document I'd quietly assembled, aligned into place like pieces of a puzzle, finally forming an image. I checked the court docket online. The case was moving forward under the assumption that his available assets were minimal. Minimal. I looked around our home, at the hardwood floors we refinished last year, at the artwork purchased during profitable quarters, at the subtle upgrades we'd made. Minimal. Then I opened my laptop and reviewed the documentation I had collected over the past 2 months. LLC registration numbers, property transfer deeds, credit line draws, operating agreements, personal credit exposure. The concealed asset wasn't theoretical anymore. It was documented. And here's the part people imagine incorrectly. I did not feel triumphant. I felt clear, because clarity strips away illusion. He hadn't simply excluded me from conversation. He had structured a legal event that would publicly declare insolvency, while quietly insulating specific holdings beyond creditor reach. And my name was still attached to shared liabilities. If the court accepted his filing as presented, creditors would look to the remaining accessible assets, including joint ones, including mine. The protection he hinted at wasn't protection of me. It was a protection of himself and the hidden property. The Arizona duplex, repositioned under layered entities, was the keystone. If revealed, it would contradict the narrative of total insolvency. If concealed successfully, it would allow him to discharge certain debts while retaining shielded assets. That evening, Daniel came home later than usual. He placed his briefcase down and loosened his tie. "I've been meaning to talk to you about something," he began. I looked at him calmly. "Yes," I said, "you have." He paused. "I filed for bankruptcy." The words were delivered gently, almost as if expecting gratitude for honesty. "I know," I replied. He blinked. "How?" "It's public record." He exhaled slowly, as though recalibrating. "I didn't tell you because I didn't want you to panic." "I'm not panicking." And I wasn't, because panic belongs to the unprepared. He began explaining. Market downturn, overextended positions, strategic reset. The narrative was polished, practiced. What he didn't mention were the transfers, the entities, the concealed asset. I listened without interrupting, not because I agreed, because I was measuring what he believed I knew, measuring how far the narrative would go. When he finished, he reached for my hand. "This protects us in the long run." I held his gaze. "Does it?" He nodded. "Yes." I withdrew my hand gently. That was the private reveal, not the bankruptcy itself, but the realization that he believed the structure was airtight, and he believed I was still uninformed. He was wrong on both counts. I didn't confront him that night. I didn't reveal what I had discovered, because once information is exposed, leverage changes, and I wasn't ready to change it yet. I needed one more decision, one that couldn't be undone. There are moments in life when you realize you're standing at a fork that no one else can see. From the outside, nothing looks urgent. Dinner still gets made, emails still get answered, the house still hums with ordinary sounds. But internally, everything is suspended. After Daniel told me about the bankruptcy, I didn't sleep much that night. not because I was spiraling, but because I was evaluating. I had options. Option 1, confront him immediately with everything I knew. Lay out the LLCs, the concealed property, the layered transfers. Force transparency through exposure. Option 2, remain silent and protect myself quietly. Separate finances, detach liabilities, prepare for long-term detachment without ever escalating legally. Option 3, formally intervene in the bankruptcy proceedings. The third option was irreversible. If I notified the trustee of undisclosed assets, the case would not proceed cleanly. The concealed property would be investigated. The court would examine intent. It wouldn't be dramatic, it would be procedural, but it would permanently alter the trajectory of his filing and our marriage. I sat at my desk the next morning with my notebook open. I wrote 3 questions. Is this salvageable through conversation? Am I financially protected if I do nothing? What outcome aligns with my moral code? The first question was the easiest to answer. He had already demonstrated that transparency was conditional. Information was released when convenient, not when appropriate. Salvage requires mutual disclosure. We did not have that. The second question required numbers. I reviewed the joint liabilities again. If the bankruptcy discharged his personal debt while shared obligations remained intact, creditors could pursue accessible marital assets, including accounts tied to my income. Doing nothing wasn't neutrality. It was exposure. The third question was the most important. Truth over comfort, dignity over drama, documentation over accusation. If he had made a strategic mistake, the legal system would have handled it. If he had acted within the law, scrutiny would confirm that. My responsibility wasn't to punish him, it was to refuse complicity. That distinction mattered, because once I understood the concealed asset clearly, silence became participation. And participation in deception, even through inaction, violated something fundamental in me. That afternoon, I scheduled a second meeting with the financial forensic specialist. This time, I brought documentation. I laid out the timeline, the transfers, the bankruptcy filing date. He reviewed everything quietly. After a long pause, he said, if these assets were not disclosed in the filing, the trustee would need to know, especially if marital liabilities are involved. I don't want to accuse, I said evenly. You wouldn't be accusing, he replied. You would be providing information. Information. Not vengeance, not spectacle. I drove home in silence. Daniel was in the kitchen when I arrived, scrolling through his phone. He looked up and smiled. You've been distant. I've been thinking, I said. About? About what responsibility looks like. He laughed lightly. You always overthink. Maybe I did. But overthinking is just thorough thinking when the stakes are high. That night, after he fell asleep, I sat in the living room with my laptop open. The bankruptcy case number was bookmarked. There was a formal channel to submit relevant information to the trustee. Clear, procedural, documented. No confrontation required. Just evidence. I hovered over the submission form for a long moment. Once sent, it could not be retracted. It would initiate a review, questions, examination. It would end the illusion of airtight protection. And it would reveal that I had been paying attention all along. I didn't feel anger. I felt alignment. Then I attached the documents and pressed send. After I submitted this documentation to the trustee, nothing happened. At least nothing visible. No alarms, no immediate letters, no sudden change in Daniel's behavior. And that was the most disorienting part. When people imagine turning points, they imagine impact. But legal systems move in layers, quiet inquiries, internal reviews, procedural pauses. Externally, our lives continued uninterrupted. Daniel went to work. I went to work. We discussed groceries. We watched the news. We slept in the same bed. But internally, I had crossed a threshold. The next step wasn't emotional. It was structural protection. I met with an attorney, not a divorce attorney, not yet, but a marital financial rights specialist. I framed everything carefully. Again, hypothetical. What protections exist for a spouse when bankruptcy is filed unilaterally? How are undisclosed assets evaluated? What liabilities remain shared? Her answers were measured and clear. If the court determines concealment, the filing can be challenged. And if joint liabilities were strategically maintained while assets were shielded, that becomes significant. Significant. I didn't need dramatic language. I needed legal accuracy. Over the next 2 weeks, I made a series of small, methodical adjustments. I removed my direct deposit from our joint account and rerouted it to my personal account. Not hidden, just separate. I updated beneficiaries on my retirement accounts. I requested written confirmation from lenders regarding which debts were legally joint and which were individually held. Each step was defensible, logical, prudent under uncertain financial circumstances. Daniel noticed the deposit change first. Why did your paycheck move? He asked one evening. I prefer a clearer separation while the bankruptcy is processing, I replied calmly. It's just procedural, he said. It doesn't affect you. It affects my name, I answered. He studied me a moment longer than usual. You don't trust me? Trust. That word again. I trust documentation, I said gently. He didn't argue, but something in his posture shifted. A week later, the first notice arrived from the trustee requesting supplemental clarification on asset disclosures. It was addressed to Daniel. He opened it at the kitchen counter while I was making tea. His jaw tightened slightly, barely noticeable to anyone else. They're asking for more detail, he said, attempting a casual tone. Routine follow-up. On what? I asked without looking up. Just standard stuff. But that night, he was on the phone longer than usual. His voice is lower, less confident. Over the next few days, more requests came. Requests about entity relationships. Requests about property transfers within 12 months of filing. Requests about lines of credit secured against real estate. The Arizona duplex was mentioned by parcel number. He read that line twice. I watched from across the room, not with satisfaction, but with observation. He looked up at me. Did you know they can dig back years? He asked. Yes, I replied evenly. They can. There was a long pause. You think this is a problem? That depends, I said, on what's accurate. He didn't respond. For the first time since filing, uncertainty wasn't theoretical. It was procedural, and he could no longer control the flow of information. I hadn't accused him. I hadn't shouted. I hadn't threatened. I had simply ensured that the full picture would be visible to those authorized to evaluate it. Silence had carried me this far. Now the system was speaking. The shift wasn't explosive. It was atmospheric. You could feel it before you could name it. Daniel began coming home later. Not dramatically late, just delayed enough to suggest complication. His phone stayed closer to him. Conversations shortened when I entered the room. Not secrecy, pressure. The trustees' requests grew more specific. They asked for operating agreements from the newly formed entities. They requested documentation regarding the Arizona property transfer timeline. They inquired about the credit lines secured against that asset. Each letter was neutral in tone, but neutral questions can destabilize carefully arranged narratives. One evening, Daniel sat at the dining table surrounded by paperwork, the same table where, months earlier, he had summarized tactical decisions as though they were minor adjustments. Now he wasn't summarizing. He was explaining, mostly to himself. They're misinterpreting restructuring as concealment, he muttered. Are they? I asked gently. He looked at me, searching for something, alignment maybe, or reassurance. You know how this works, he said. Asset protection is normal. Protection from what? I asked. He hesitated. Exposure. Exposure. That word felt heavier now, because exposure was no longer theoretical. It was procedural. Within weeks, creditors who had remained passive began filing objections. The trustees scheduled a more formal review of asset disclosures. Daniel's confidence thinned, not collapsed, thinned. The men who once clapped his shoulder at galas became harder to reach. Calls weren't returned as quickly. Meetings were rescheduled. Reputation shifts quietly before it shifts publicly. At home, he grew irritable, not toward me, but toward circumstances. They're overreaching, he said one night. They're verifying, I replied. He exhaled sharply. You think I did something wrong? I met his eyes. I think you assumed no one would look closely. The room went still. That was the first time I saw it. Recognition, not guilt. Recognition that I was no longer peripheral. Meanwhile, my own position strengthened. Because I had separated income streams early, my financial exposure was clearer. Because I had documented timelines, my involvement in the asset transfers was demonstrably absent. The trustee requested a statement from me as the spouse. I provided one. Factual, precise, without commentary. I confirmed the date I became aware of the bankruptcy filing. I confirmed I had not participated in the formation of the entities in question. I confirmed I had not authorized the joint line of credit beyond standard marital consent parameters. No accusations, just dates. Information is powerful when it's unemotional. The concealed asset, the Arizona duplex repositioned under layered ownership, became central to the review. If deemed intentionally undisclosed, it wouldn't simply complicate the bankruptcy. It could invalidate it, and if invalidated, debts wouldn't be discharged. Protections wouldn't apply. The narrative of insolvency would fracture. Daniel began pacing at night. He'd stand in the kitchen, lights off, looking out the window. This wasn't supposed to spiral, he said once quietly. Spiral. I didn't respond, because nothing had spiraled. It had been examined. An examination feels chaotic only when you are relying on obscurity. The consequences weren't loud, they were procedural, and the procedure doesn't argue, it uncovers. Panic doesn't always look like shouting. Sometimes it looks like over-explaining. Daniel began narrating his decisions out loud, almost as if rehearsing defenses. It was temporary positioning. Everyone shields assets before filing. It wasn't concealment, it was restructuring. The more he explained, the clearer it became that the ground beneath him was no longer stable. The trustee scheduled a formal 341 meeting. Creditors present, disclosures reviewed under oath. Daniel spent nights at the dining table assembling binders. His movements were sharper now, less fluid, paper clipped, unclipped, rearranged. At one point, he looked up at me and said, "You could help, you know. You're good at organizing this kind of thing." I held his gaze. "I wasn't included in the structuring," I said calmly. "It wouldn't be appropriate." That word, appropriate, landed heavier than accusation. He nodded slowly. For the first time, I saw something close to regret flicker across his face. Not regret for the concealment, regret for the exposure. The Arizona property became the focal point. The trustee's supplemental inquiry outlined the timeline clearly. Transfer to LLC within 12 months prior to filing. Credit line secured against the asset. Significant drawdown of funds. Omission from initial bankruptcy schedules. Under oath, those details matter. The morning of the 341 meeting, he stood in the hallway adjusting his tie. "This is procedural," he said, as if reminding himself. "It'll smooth out." I didn't contradict him, because smoothing out requires symmetry, and the record was no longer symmetrical. When he returned that afternoon, he didn't remove his shoes immediately like he usually did. He walked straight into the living room and sat down heavily. "They're investigating intent," he said flatly. Intent. That's the line between error and deception. If a court determines omission was intentional, consequences expand. Bankruptcy protections can be denied. Cases can be dismissed. Referrals can be made for further review. He rubbed his temples. "They think I was trying to keep the property out of reach." "Were you?" I asked softly. He didn't answer. Instead, he said something else. "I was trying to protect what I built." That was the first honest sentence. Not protect us. Not protect the family. Protect what I built. The shift in language mattered, because suddenly the narrative was no longer about shielding me from stress. It was about preserving personal control. Over the next few weeks, additional documentation was requested. Delays mounted. Legal fees increased. Creditors grew less patient. The clean reset he envisioned was dissolving. And here's the truth. By the time he realized the concealment might unravel the entire filing, it was too late to quietly amend. Because the trustee had already seen the discrepancy. You cannot clarify something once scrutiny has begun without raising further questions. Amendments look different after exposure. One evening, he sat across from me at the kitchen table and said quietly, "If this falls apart, it changes everything." "It already has," I replied. He looked at me then, not as a stabilizer, not as background, but as a witness. And witnesses, once aware, cannot be erased. The confrontation didn't happen in a courtroom. It happened on a Sunday morning. The house was quiet. Light filtered softly through the blinds. Daniel was sitting at the kitchen table, staring at nothing in particular. I poured coffee for both of us and sat down across from him. No raised voice, no rehearsed speech, just clarity. "They're considering dismissal," he said without looking up. "I know." He nodded faintly. "If they deny discharge, creditors can pursue everything." "Yes." He finally met my eyes. "Why didn't you tell me you knew about the Arizona transfer?" I held his gaze evenly, because I needed to understand whether you were going to tell me. Silence stretched between us. "I was going to," he said. "When?" I asked calmly. He didn't answer. I continued, not with accusation, but with structure. "You transferred the property within a year of filing. You secured a line of credit against it. You did not disclose it. My name remained attached to joint liabilities. That isn't protection. That's repositioning." His jaw tightened. "You went to the trustee." It wasn't a question. "Yes? Why?" "Because I won't be legally exposed for something I wasn't informed about." He exhaled sharply, but not angrily, more like a man confronting a version of reality he hadn't calculated. "You could have come to me." "I did," I said gently, "multiple times in smaller ways." He leaned back in his chair, staring at the ceiling. "You think I was trying to deceive you? I think you believed you could manage the outcome without involving me." "That's not the same thing." "No," I agreed, "it's not." There was no shouting. No accusations about betrayal or character. Just definitions. He looked tired. "I was trying to preserve something," he said quietly. "Preserve what?" my position, my leverage, my reputation. There it was again. Not us, not stability, position, reputation. I nodded slowly. And in doing that, I said, you were willing to risk mine. That sentence landed softly, but it didn't need force. He didn't argue, because he couldn't. The trustees' review had already uncovered the concealed asset. The bankruptcy case was on unstable ground. His legal team was negotiating damage control instead of executing a strategy. Control had shifted. Not because I humiliated him, not because I threatened him, but because I removed obscurity. You've changed, he said after a long pause. I stopped assuming I was included, I replied. He studied me carefully then, as if seeing a version of me that had always been present, but never activated. What happens now, he asked. That depends on what you choose to acknowledge, I said. There was no anger in my voice, just truth. And truth, delivered calmly, leaves very little room for deflection. The bankruptcy case was eventually amended under scrutiny. Not quietly, not cleanly. The trustees' investigation forced full disclosure of the Arizona property and the associated credit line. The attempt at strategic shielding didn't collapse into scandal, but it did dismantle the narrative Daniel had tried to construct. Discharge was limited. Certain debts remained enforceable. Legal fees multiplied big. His professional circle adjusted its tone. Nothing theatrical happened, but everything recalibrated. We separated 6 months later, not because of the bankruptcy itself, because of what it revealed. There's a specific kind of fracture that occurs when you realize your partner didn't see you as an equal in critical decisions, not malicious, not violent. Just optional. I didn't leave in anger. I left in alignment. By the time paperwork was filed, I was financially stable. My accounts were separate. My exposure had been clarified. The documentation trail had protected my legal standing. More importantly, my self-perception had shifted. For years, I had accepted being categorized as solid, reliable, low maintenance, emotionally steady. I still am those things, but now I define them differently. Solid doesn't mean silent. Reliable doesn't mean uninformed. Steady doesn't mean static. The most surprising part of all of this wasn't discovering the concealed asset. It wasn't the bankruptcy filing. It was discovering how comfortable I had become being underestimated. There's a quiet seduction in invisibility. No expectations, no confrontation, no spotlight. But invisibility can slowly turn into erasure. Today, I still work in compliance. I still carry my black leather notebook. I still prefer calm conversations over dramatic ones. But I no longer allow information about my own life to bypass me. I ask direct questions. If answers are vague, I follow documentation. If something feels structurally misaligned, I examine it early, not months later. Daniel once told me, you don't need to get into the weeds. He was wrong. The weeds are where truth hides, and I am very comfortable there. I don't hate him. I don't even consider him a villain. He made a series of strategic decisions under pressure. He believed control meant containment. He believed protection meant exclusion. He underestimated the quiet variable in his equation. That was his error. I underestimated myself. That was mine. I don't raise my voice now to be heard. I simply ensure I have access. Because access is power, and power doesn't need to announce itself. It just needs to be present. When people hear this story, they often focus on the twist, the hidden property, the bankruptcy filing, the moment the concealed asset shifted, the entire case. But that's not the heart of it. The heart of it is this. Information withheld inside a marriage is not protection, it's control. And control built on an assumption eventually collapses under scrutiny. I didn't win anything. There was no victory party, no dramatic courtroom triumph, no public apology. What I gained was quieter than that. I gained clarity. Clarity about my legal standing, clarity about my financial autonomy, clarity about who I am when pressure replaces comfort. The asset he concealed turned the entire case upside down. But what truly changed everything was the moment I stopped confusing calm with compliance. There's a difference between being peaceful and being passive, between being supportive and being sidelined, between trusting and refusing to verify. If you are someone who prides yourself on being steady, on being the reasonable one, on not overreacting, this is not a warning against kindness. It's a reminder that steadiness should never cost you visibility. You are allowed to ask for documentation. You are allowed to understand the structures that affect your name. You are allowed to step out of roles that were assigned without your consent. Quiet dominance isn't about overpowering someone. It's about knowing exactly where you stand and ensuring the system reflects that truth. I don't tell this story to encourage suspicion. I tell it to encourage awareness. Because the most dangerous sentence in any partnership is, You don't need to worry about that. Maybe you don't, but you do need to understand it. So I'll leave you with this. Have you ever mistaken silence for safety, only to realize later that what you really needed was clarity?